Practice before the IRS is broader than most people think. It's not just going to tax court. It includes representing a taxpayer in front of the IRS, like calling to negotiate an installment agreement, responding to exam questions, or arguing a position at a conference. On the EA exam, they love testing where the line is between simple information sharing and true representation. The Annual Filing Season Program, or AFSP, is voluntary. It's basically the IRS saying, if you're not an EA, CPA, or attorney, you can still prove you're trained. If you meet the requirements, you get a record of completion. The key exam angle, AFSP, doesn't make you an enrolled practitioner. It only unlocks limited representation rights and only in very specific situations. To earn the AFSP record of completion, the normal checklist is 4 items. First, 18 hours of IRS-approved continuing education, including a 6-hour annual federal tax refresher, or AFTR. Second, you pass the AFTR comprehension test. Third, you have a current PTIN. Fourth, you consent to Circular 230 duties and restrictions, which gives the IRS authority to regulate you under those standards. Some unenrolled preparers can skip the AFTR course and test and still get the record of completion, as long as they complete at least 15 hours of qualifying CE. The big buckets are active participants in certain state preparer programs, people who passed C Part 1 within the last 2 years, certain VITA volunteers with PTINs, and a couple of accredited tax credentials like ABA or ATP. On the exam, watch for that AFTR Exempt wording. Now the core rule. An unenrolled preparer has limited practice rights. If they have a current AFSP record of completion, they may represent a taxpayer only during an IRS examination and only for the year or period covered by a return or claim for refund that the preparer prepared and signed. No AFSP record? Then they generally can't represent the taxpayer in the exam at all. Even with AFSP, there's a hard cannot do list. Unenrolled preparers cannot represent taxpayers before appeals, revenue officers, counsel, or similar Treasury employees. They also cannot sign documents for the taxpayer, execute waivers, extend statutes of limitations, execute closing agreements, or execute claims for refund. On the EA exam, these are classic trap answers because they sound like normal representation tasks. One more nuance. Some people can represent without being enrolled or AFSP at all because of their relationship. An employee can represent their employer. A fiduciary, like an executor, can represent the estate. And in certain cases, a family member can represent a relative. These aren't AFSP rights. They're separate relationship-based permissions, and the exam will mix these fact patterns to see if you spot the real reason representation is allowed. Which of the following actions does not constitute practice before the IRS? The choices include furnishing information at the request of an IRS employee, signing a closing agreement about a tax liability, communicating with the IRS for a taxpayer about the taxpayer's rights, and representing a taxpayer at a hearing. Think about it. What's the one that's more like cooperation than representation? The correct answer is furnishing information at the request of an IRS employee. By itself, that's not practice before the IRS, and generally anyone can do it. A tempting wrong answer is communicating about the taxpayer's rights because it sounds informal, but that's still representing the taxpayer in front of the IRS, which is practice. Which of the following disciplined practitioners may represent clients before the IRS? The options are a practitioner who has been disbarred, a practitioner who has been publicly censured by OPR, a practitioner suspended for 2 years, or that none of them may practice at all. Think about what each type of discipline actually does to practice rights. The correct answer is the practitioner who has been publicly censured by OPR. A public censure is a reprimand, but it doesn't automatically take away the right to practice. The tempting wrong answer is none, because disbarment and suspension do block practice, but censure alone does not.